let's start with this flow chart, which is about commercialization of research results, irrespective whether it is a research result at a university or other public research organization, or in an innovation-oriented company. Don't be afraid, I will not go through the whole chart. I will just pick the most relevant parts. So it is the researcher or engineer who will generate a result, and then it comes the question, this result, which goes through a first assessment, or actually even stronger, an evaluation whether it's a feasible it's a feasible invention and it has a business potential. Then it is a question or a set of questions, what you can see here, whether the intellectual property production is possible. If it cannot be registered, can it be commercialized as a know-how? And what happens if the intellectual property is granted? Okay, let's start with the definition. So I was a researcher. I graduated as a physicist, so I always love to start with definitions. This is how I was socialized. Take the definition. The most relevant definition is coming from the World Intellectual Property Organization, which says that the intellectual property refers to creation of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. Okay, it sounds very compact and very good, but here I have to take some pieces. And the first stop is that creations of the mind. Here it comes a very interesting, very modern consideration. Recently, there was a legal case in the UK that an artificial intelligence developed an invention, and the owners of the system wanted to patent it. And it was refused because it did not satisfy this criteria, which means that creation of the mind. It was not a creation of the mind, but it was a creation of a computer. So it was not an intellectual property. And the other very important thing, it is not limited to technical and scientific things, but it is covering many other things like literary and artistic works, design, symbols, names, and images. And the very most important thing, which is at the very end of this definition, is in commerce. So we are talking about a commercial process. It is related to commerce. It is related to business. This is really, really important. Intellectual property belongs to a specific group of goods which are immaterial goods or intangible assets, which means that it does not have any physical appearance, but it's a set of legal rights which results for intellectual activity of industrial, scientific, literary, and artistic fields. So these are legal rights. Therefore, you cannot possess it, so you cannot protect it, you cannot lock it. And as it is a set of legal rights, your rights can be enforced if there are any legal dispute, as any other legal dispute should be your rights enforced in courts. And here it comes a very interesting question. Why to protect? If I deliver a normal training course and the audience is sitting just in front of me, I usually ask this question, and there are very interesting answers coming back. The usual answers sound like I don't want the others to use my inventions. And okay, then I ask, okay, why don't you want the others? Are you greedy or what's wrong? Or I don't want that others will steal my invention. What's wrong? I mean, you should be very happy that your invention is for the benefit of the society or for some people. And then gradually, I guide the people to the point when they understand that a protection is a very complex thing. First of all, that's right, that I want to exclude the others from making money out of it. And here it comes the first point. I want to exclude others making money out of it. So, which means that do I really protect only my invention? Not only, I protect also my markets. So it is the markets what I protect. And if I have my market where the others are excluded, then what is that called? That is called monopoly. So through the protection of my intellectual property, I establish a monopoly. Okay, so here are the major aims of protection to help strike the right balance between interests of innovator and the wider public interest. So how to commercialize it, how to bring it to the public. And of course, people want to have financial benefits through a monopoly. It's a very, very important thing. And through this monopoly, you can reach a price premium. Because if you have a monopoly, what will determine your price? The price will be determined by you, yourself, and of course, by the market. Market, I mean, how high price will be accepted by the market. But what is definitely not determining the competition, it is, or the price, it is the competition. So you don't have competing products. And this is a very important point. Now, just to mention you a very interesting story about the blue pill, which is a product of Pfizer. Pfizer developed this unique pill and put it onto the market at a price range about 60 euros a box. And then the patent expired about 2 years ago. And in my country, the next week, 5 competitors put their generic pills onto the market at a price level of, let's say, 25 euros. So here you can see the price premium was very high, 60 euros, and but the competitors could make it in 25 euros. So here are 2 questions. Why was it 60? First of all, because of the monopoly. Second, what was the reaction of Pfizer for that competition? Usually I ask this question as well, and I give 3 options, or actually 4 options, 20, 25, 30, 60. There could be arguments behind, but the right answer is something like 30 euros because the brand is there. It is the most well-known of its category. Okay, so the price premium is already discussed. By the way, this price premium will cover all those costs and expenses which were spent on development of this pill, which is in the range of a couple of billion euros. And of course, that price premium will bring back the invested capital to the IP owner. And of course, at a later stage, well, it's a pure profit what the shareholders are very happy about. Okay, it gives also the possibility to license out your invention and to generate revenue streams. Marketing credibility, when you hear, okay, it's a patented technology, patented product, then it gives kind of credibility, which means that it was already checked and qualified by some people in the patent office. If you have a small company, especially a startup company or a spin-off company, then for investors that gives a kind of security, and for or other partners than investors, that okay, you have a patent, it is protected, so you can keep an advantage against the competitors. Gain time for further development, again in the pharmaceutical industry, when a new molecule is synthesized and it is already in the lab proven that it is a drug candidate, then it is immediately patented. Then, of course, it takes many years to fully develop it. But just imagine if it is fully developed and spend this couple of billion euros, and suddenly it turns out that their competitor just came to the market, then all this couple of billion is gone. Okay, prevent others from using their inventions without permission. That is obvious, and here it comes. Potentially prevent competitors from entering market, and here it is the market issue. So you protect your market as well. Okay, what are the forms? There are two main categories: registered and unregistered intellectual properties. For inventions, the most well-known is the patent. I will come back to details. The utility model and the plant variety protection. What is the utility model? It is not so well-known category. First of all, utility model does not exist in the Anglo-Saxon legal system. It is only understood in the Roman legal system. So I would say most of Europe except the Nordic countries and the UK. And the utility model is, let's say, a simpler, smaller version of a patent, but I will come back to that as well. For protection of goods and services, trademark, industrial design, and mainly for food products, geographical indication. Concerning the unregistered IPs, here is a list of the possible categories. Copyright. Copyright is usually known as protection of artistic works like literature, like music, but also in technology there is a new understanding of copyright. Why? Because in Europe, software on its own cannot be patented. Only if it is a part or a driving component of a hardware, then it can be patented, but not on its own. Therefore, as the codes are written down as if it were, let's say, like a poem. So it is the protection philosophy behind the copyright on softwares is this one, that when you write it down, it is your creation. And it's strange enough, but copyright is an automatically generated right. So you don't have to go to patent office. You don't have to register it anywhere. When you write it down, it is automatically protected. If somebody wants to use it, either they have to refer it or they have to pay fees for it. Database right is very similar to the previous one. And here it comes the confidential information, trade secrets, and know-how. Know-how is mainly for industries. It's similar to patents, but not registered. But here you don't have to forget that know-how is not something what you have in your head, which is the case many times, especially with startup companies and inventors, or even spin-off companies when the leading researcher, he knows how to do things, but he never writes it down because he's afraid that somebody will steal it. In this case, the major risk is the inventor himself or herself. Why? Because this know-how is stored in a very sensitive memory, which is located in the skull of the inventor, and this memory unit can be damaged in many ways. A disease, an accident, or whatever uh, can destroy the know-how, and then nobody ever can replicate it. So what we call a know-how is a written document, sometimes even deposited at an attorney office, or even in some countries it is possible to deposit the know-how document at the intellectual property office of that country, so National Intellectual Property Office. Also, unregistered designs and unregistered trademarks exist. For example, unregistered designs are mainly in fashion business, let's say, because fashion business, as one of the most innovative sectors, as they come out a new set of products every half a year, the spring and summer sets and the autumn and winter sets. So every half a year, new products are coming out, and there is no use and no time for registering the designs, but still it is their own design. So it is a short life cycle things. Okay, but here it comes even more important question: when not to register, when not to protect. There are many cases. I mean, you wouldn't believe that there are many cases. So the invention is hard to reverse engineer and thus to copy. This applies to compositions, beverages, composites, processes, which is very difficult to reverse engineer. So, which means that almost impossible to copy. The classical case is Coca-Cola. Coca-Cola has never ever been patented because still it is not possible, or very difficult. I have never ever heard that anybody could reverse engineer Coca-Cola, and therefore it is very difficult to reverse engineer. Which is what is not listed here is one more consideration which should be added here, that why not to patent? Because patenting means that you publicize your invention. Wow, that's very interesting, because just think it over. When you patent, what you do, you send your invention to the national patent office or European patent office, or whichever patent office, and then if it is granted, then it will be published. Here it comes a question. Do you really want to publish your invention? Do you want to have the others being able to see it and understand it? Sometimes it's better not to. Keep it secret. Although keeping secret is also not easy. Or the other question is whether the enforcement of the patent would be difficult. Which are the typical cases for this category? The patent is easy to invent around. Well, which means invent around means that somebody is using a little bit different component, little bit different approach, although the functionality will be the same, but it will not infringe your patent. So they can almost copy it without infringing your patent. Or no easy way to detect infringement. Let's say you have a patent for a process or for a production technology, and your competitor will copy it in their manufacturing plant, which is a closed space. Do you have a chance to go there and see it and to prove it that it was copied? I hardly believe that you have the possibility to do that. Or it is copied in a geographic area where you don't really have access to. Or there are no sufficient resources to enforce the patent. Wow, that is a very interesting consideration. I usually make this hypothetic consideration, which is actually can be true, and I know many, many cases. There is an inventor or a small company having an invention or even a patent, and then suddenly a big company, let's say from the US, from Japan, even more from China or India, it's copied. What will you do as a small company? Will you go to the local court, district court or city court and sue them? Okay, you will sue them. And as they are a big company, they have the resources, which means money, to buy the best attorneys of your country. And then this legal case will go on for 3 to 5 years typically. And most of the attorneys, what you are able to, to pay will not work, hardly ever work only for success fee. They will ask hourly fee, which is usually very high. Would you be able to finance that legal process? So it's a very, very important consideration. And here it comes another question. The cost of patenting possibly exceed the commercial value of the patent. Okay, so here we come again to a point. Patenting costs you money to pay the patent attorney who will put together the claims or all the patent application, paying the fees, the National Patent Office fees, and then going to international phase. It could cost you a lot of money. And when we are talking about putting money into a business or a potential business, that is called investment. So if you have an investment, then you have the expectation of return on investment. Aha. Do I have a chance to have a return on investment? Well, it's very, very interesting. Again, if it is easy to invent around, then you can hardly have a return on investment. If the invention becomes obsolete very quickly, then it has no sense, because the patenting process, even at National Patent Office, takes 1 to 2 years. And especially in gadget business, the life cycle of the product is just about 2 to 3 years sometimes. So then it is obsolete, and then your patent will not protect anything, or it is a too small niche market. Even more, from a practical example, I can tell you that especially with some engineering inventions, there is something what I call engineering protection. What do I mean by engineering protection? Uh, just for example, putting the control unit in a self-destroying box. Giving you a practical case. We had a client who developed a granulating machine, which converted various types of powders into granulates. And the granulates could be adjusted in size distribution, hydrophobic or hydrophilic properties, and so on. So, and the two major units of this machine was the control unit, which was really smart to adjust all the process parameters to obtain the proper granulates, and of course all the hardware around. And it was a question whether it should be patented or not to be patented. And what I suggested as a consideration, to put the whole control unit into a black box, and if somebody opens the black box, it will be self-destroying, physically and the software as well. So, which means that you make it is very, very difficult to be copied. It's wonderful because then you don't have to go for any legal process. If somebody is unfair and wants to open this black box for whatever reason, then the whole machine will never work again unless they buy a new control unit. And then if they buy a new control unit, then you know that they wanted to copy it, they were unfair, and then you can charge whatever price you want. So it is a very interesting concept of the engineering protection, which is also possible for softwares as well, to protect it by coding. But here comes also a very interesting question. Is there a perfect protection? There is no perfect protection. It is like protecting any of your other goods, just to lower the possibility for being stolen. So there are always techniques and technologies to unlock your locks, but the more the stronger protection you put, the more difficult it will be to unlock it. So it's the same story here. Okay, let's go down to the explanation. What is a patent? Patent is a set of exclusive rights to commercially exploit the invention granted for a set period of time in exchange for disclosure of invention. So here are two very important statements. First of all, it is a right for a given period of time, which what we shall see later is maximum 20 years, but sometimes shorter, because if you don't pay the maintenance fees, then your protection will be gone. And also what I already mentioned, in exchange for disclosure of an invention. So again, do you really want to disclose it? Do you really want to publicize it? So it's a prohibitive right, as you mentioned, forbids others commercially to produce, sell, work, use, import, and possess the invention. And there are many limitations as well. So here is a definition of a patent. The patent provides protection of the invention to the owner of the patent. I will come back to here, ownership. I will come back to it. The protection is granted to limited period, generally 20 years, for pharmaceutical and pesticide products. It can be extended by another 5 years. What is patentable? These are technical inventions which solve technical problems, which means these are products, equipments, apparatus, processes, methods, or use of the product which fulfills the following three criteria. Is a new thing, so the novelty. Its essential differs from current state of the art, which means that it's inventive, and is capable of industrial application, must have at least one practical purposes, must be reproducible. So these are the three criteria what the patent office will investigate whenever you file it. The protection is up to 20 years, as it was already mentioned. The territoriality patents are granted by national patent offices typically, or by regional offices like European Patent Office. But then there is if you want to go for an international phase, then there is this Patent Cooperation Treaty, PCT, which gives you a protection for 1.5 years before you go to other national phases. And here it comes a very, very interesting point, the territoriality. How do you determine in which countries you want to protect? As I have already mentioned, you protect not only your invention, but also your market. So if you have a market entry strategy, if you know which markets you want to explore yourself, then you know which are your markets. Of course, those markets should be protected. If you cannot reach certain markets, why to protect there? It's not your market anyway. So it's a very, very important consideration when you want to patent or when you want to extend your patent internationally, to which markets you want to have a patent, where you want to have protection. For financial reasons, because in each and every country where you want to extend your patent, you have to pay fees for registration and later on maintenance fees every year. Would you be able to do that? I must tell you that a couple of years ago, I was working with SME in Italy producing plastic containers for vaccines, which it doesn't sound really a very high-tech business, but I must tell you, when I had a look on their injection molds, wow, they were fantastic. And they had patents on these injection molds, and they paid 30,000 euros a year only for maintenance of their patents. 30,000 euros every year, which is not a small amount of money. Okay, and there are certain things which cannot be patented: discoveries, health, treatments, objects, or inventions which are either illegal or contrary to moral standard and public order. Okay, here are the major way. National PCT or regional European Patent Office, the European Union patent is already in place. here are just some cases. I don't want to go too much in details. To go to a national patent office or going to the PCT or regional application, here are some sequences, or you can go immediately to others. I will just skip this slide because these slides because it is too much details. Yes, these are too much details. You will have access to this presentation if you are interested in details. Then you can see the details. But here we come to a very, very interesting question. The so-called preliminary researches. If you want to do, if you consider to have a patent, or even if you don't consider to have a patent, but you start developing a new product, a new technology, what you should do is do the patent search. I don't go to the details of patent search. Sorry for this very fast one, but it should be done by an expert. But here it comes, the most important part, and this is the one. Freedom to operate search. What is this freedom to operate search? Freedom to operate search means that, of course, you as an innovative company or a researcher or an inventor, you are very, very smart. But in many, many cases, you are not the only one who is so smart. So there might be some other smart people who had already thought about the same solution of the same problem. And they might have had patented that solution. So before you start any project, it should be compulsory or strongly advisable to do this freedom to operate search, which means that you do a patent search and you check the patent landscape and check if you would not infringe any existing patents. Even if you unintentionally infringe a patent, it is infringing. And what may happen? It may happen that, okay, you develop a product, you go to the market, and then suddenly you receive a letter from an Italian company saying that, hey guys, you're infringing our patents or patent. What would you do? You have various choices. Choice one, you stop your business activities on those markets. It was a lot of money to enter those markets. You will lose all that money. Or you go to countries where the patent is not valid. Usually these are not the easy markets. So it will be a difficult market with a lot of money, again, invested into market entry. Or you just try to say that, no, according to our point, we are not infringing because our product or solution is different than your patent. So it is not infringing. Then probably it will end up at the court because the Italians will say, okay, it is still an infringing. Or you just simply neglect the Italians, and sooner or later they will go to the court, and then there will be 3 to 5 years dispute, and then probably you will be fined, and then either you pay your fine from the profits you generated, or you just close down your business. Or there is an option that you sit down with the Italians and you say that, okay, it was an unintentional story, but we still want to go to the market, and can we negotiate a potential or a possible licensing agreement? What the Italian will either say no, or they will set the price at at a very high level. So to avoid all these troubles, you have to do this freedom to operate search, which is just checking the patent landscape. Okay, so that was all what I explained here, and when to do it, as soon as possible. Patenting, that costs money. Here are some examples of Euro PCT patent. It's this amount of money. European patent is this amount of money. Estimated American cost, itemized. Here we are talking about a couple of $1,000, and here are just estimated US patent cost for attorney fees. As we all know, the American patent attorneys are not the cheapest guys. And here are some Far East costs. Here I'm talking about a range of €1,000. Okay, utility model. It is also a form of patent available in some countries. These are simpler ones. Even in some countries, it's called small patents. For example, in Slavic countries, Mali patent. And the lifetime varies in different countries. Typically, 6 to 10 years is the most. So if the product life cycle is not so long, then and it is not so complex invention, then a utility model can be okay. And even if you are not intending to enter markets which are regulated by Anglo-Saxon legal system. A trademark is typically a sign which for distinguishing your goods or services from the others, and just here are probably the most well-known ones. It should require the requirement is to be unique, is not descriptive, and should not be similar to others. This last point, I mean, you also might know some Chinese tricks how to look the same with same fonts, but changing some letters, or even more tricky, like for example, Abibas instead of Adidas, Abibas, and you just mirror the two Ds into Bs, and then they say it's different, although it is not. How to obtain a trademark potential. Same story like patent, but it's much simpler and much cheaper. There is a national, international, and it should be done at the patent office. So it's the same story. Industrial design is more or less the same, but here we are talking about the 2 or 3 dimensional shape of the product, how it appears, and this gives a protection for 25 years, and same story as it is for the previous one, as for the trademark. And unregistered designs, I don't want to spend too much time on that. Copyright is already discussed. I have to emphasize again, it's an automatic right. So software. I don't go into software at all because it's a little bit different philosophy behind of protection and licensing of software. So if you're interested, you can see the details in the presentation, but I don't want to touch upon this topic. So sorry to put you in a roller coaster, but it's really a different type of, even the expressions licensing means something different than in engineered products. Okay, if you cannot have a registered IP, can your invention as a know-how be commercialized? Of course it can be, even it can be licensed, but of course there are certain setbacks, like weaker protection, protects only against unfair acquisition, and as it was already mentioned, it's hard to keep secrets. Here is one case from the Jagiellonian University in Krakow, Poland. They licensed to a UK company a computer system for assessing the risk of cardiotoxic drugs without patent, but it was a know-how and it was easily licensed to this UK company. For researchers, it is a very interesting question, publication versus patenting. Publication. Most of the researchers are measured according to their scientific merits, and scientific merits are publications with impact factors and citation index and conference appearance. Okay, but then if this invention is not only for scientific publication, but it has a commercial value. So what to do? As I was a researcher myself, I know that I always wanted to publicize as fast as possible, just to demonstrate to my fellow researchers that, hey guys, I am very smart and I have this and this result, and I wanted to show to you. But if you have if your invention has a commercial potential, then publication will just kill your patent. Because you remember when I listed the 3 criteria for patenting, the first one was novelty. And if you had, let's say, a very nice conference presentation on the European Material Research Society, and then it was published in the proceeding of this conference, then of course there is a very, very high chance that during the novelty search in the patent office, this publication will be identified, and then the novelty is gone. So your patent committed suicide, even though it is your publication. So we suggest the earliest you can publicize if you are a researcher after filing the patent, but the most secure solution is when it is granted. And I promise you to come back to the question of ownership. Of course, if you're an individual independent inventor, then you keep your ownership. But if the invention is created under employment, it is your employer who is the owner of the patent. So it's a very, very interesting question. If you're a researcher at a public research organization, it is the university or a research institute is the owner. However, in most of the universities and the public research or other public research organizations, there are so-called intellectual property statute, which regulates the rights of the inventor, which means when it is commercialized, there is a certain financial compensation what the researcher will receive. the situation at companies. That is really something different, because in most companies, even in big companies, it is not always regulated, which actually should be. Innovative companies should have a kind of statute or a kind of written procedure for compensating the engineers who made a very valuable patent. Why? Because if there is no statute, the management can decide, okay, it was your duty, so you will not be compensated. I could hear, I have heard some very, very nasty stories when this was the case, and the engineer has never ever made any new patents because there was no motivation. So it is very, very important to have an incentive for the inventor to continue his very valuable work. But anyway, the ownership is at the employer. But sometimes it happens, especially in contract research or even more in collaborative research projects, that two or even more parties are contributing to the generation of that invention. Especially in big European projects like in Horizon 2020, many of the results are generated by 3, 4, 6 parties. The solution for this case is the so-called joint ownership agreement. Here is a model case. A public research organization and the business partner developed an invention together, and let's say they contributed to the invention 50-50. But here it comes a very important point that, okay, it's generated, but then you have to pay, as it was demonstrated before, quite some money for the legal process of the registration, patent attorney registration fees, maintenance fees, and so on and so on. And in some universities are not ready to pay for it, but the business partner will pay for it. So finally, you agree, let's say 30 to 70%. Of course, within the public research organization, the inventor have this compensation upon commercialization, which I mentioned before, according to the institution intellectual property statute. Okay, when it is about commercialization, as we can see, here are two owners, but most probably the business partner wants to commercialize. If he wants to commercialize it, has to make an agreement with the co-owner in the form of joint ownership, or actually a license agreement, under what conditions he can commercialize. Either royalty-free or royalty-bearing. What royalty is, that we shall hear the detailed explanation on the 15th of April in the next session of this serial of seminars. But royalty bearing means that you pay a regular compensation based upon the income generated by this product. Or there is a Brussels condition, what I have never ever understood, under fair and reasonable conditions. For me, it's not understandable, because either you pay money or you don't pay money. And if you pay money, then you have to negotiate and agree upon the financial compensation. So it gives the possibility for the business partner to commercialize it. It's fine, but also it has to be agreed whether the university can use it for further research activities. But what if a Japanese company comes to the university and says, hey guys, I know that you have a very interesting patent. we want to commercialize it. We want to sign a license agreement. What should be the reaction of the university? First of all, they should be very happy that somebody's interested. Second, that they have to discuss it with the co-owner, because the co-owner may have some objections. Even in most of these agreements, there is a veto right for the business partner if a business, a third party, wants to license it and it is against their prime business interest. Of course, if the Japanese company wants to bring the product onto a market which is not accessible for the business partner, that's wonderful, because let's say that the business partner cannot reach the Far Eastern market. So the third party, the Japanese company, can cover that market and pay royalty for the owners, for the original owners. So which means generates additional revenue from markets which are not accessible. Of course, to agree on all these things, you have to develop a joint ownership agreement. And I must tell you that not when you are ready with the project and when money is at your side, but as early as possible, already at the beginning of the project or early stage of the project. And it's usually the classical issues: who are the parties, what is the subject of the agreement, what are the shares, who is responsible for protection, what are the obligations, and some many other issues like using further research mainly at the university, licensing issues, and so on and so on. And the last chapter of this presentation is the IP valuation. As we are talking of an intellectual property, as each and every property has not only an owner, but it has a value. And here we are talking about there are two expressions in English. Evaluation is a qualitative valuation, while what I call valuation is a financial valuation of an intellectual property, which is not an easy story. And there are many, many reasons why to do it. I don't want to go in details, but decision-making, communication, especially for public research organizations, it is very, very important to have, for PR reasons, to say that, okay, we have this and that many patents at the value of this and this million euro. That gives a reputation to the researchers as well as for future students. Value creation. Just imagine if you are a startup company or a spin-out company and you want to attract an investor. What can you put down against their financial capital? Your intellectual capital in the form of a patent or a know-how. And if you cannot determine the value of your intellectual property, then how to negotiate and agree upon the shares with the investor putting down their cash. And here is my favorite slide, which is, I call it inequation, which represents cost, value, and price. Cost is what it was the cost to produce it. The bookkeepers, they love it because these are numbers, what was spent on the development of this intellectual property, but which is missing from here is the intellectual contribution, which cannot be put down as a cost factor. So I don't like it. So when you face your bookkeeper and say that, okay, let's determine value of the IP, the bookkeeper will say, yes, okay, we just take into account the cost and that's it, which is not good. Of course, maybe for bookkeeping purposes, it's okay. But if you want to attract investor, if you want to license it out, or if you want to sell the property, then this will be the worst value. But the value as such is your preference, your expectation. Here it is the market expectation. So how much money would it generate? So this is your expectation, and the price, which differs from the value, which is the amount of money what the buyer or the licensee is ready to pay for it. And this is the starting point could be the value, but finally the price will be set through a negotiation process. Just to give you an example, if you have a very similar case, if you have a car and you want to sell it on the second-hand car market, you say that, okay, I want to sell it for, let's say, 10,000 euros, and somebody is coming and saying that, okay, I like this car, but I'm ready to pay only 9,000 euros. And then you start to negotiate, and finally you shake hands at 9,600. And that is the difference between the value and the price. But the problem here is, unlike this example, you don't have a comparative price. For the car, you have very, very good comparative price, because if you look at the announcements for same brand, same model, same mileage, same age, then you can have a very good idea how to set the value of the car, and then the price and the value will not differ too much. But for your intellectual property, as it is a unique thing, you don't have a comparative price. So it is a lot more difficult, and I could see transactions when the price was only a small fraction of the value which was set originally, which means that let's say 10 to 20% of the originally set value. Yeah, I mean, I don't go too much into the details how to do it and what are the methodologies to do the IP valuation. It's usually done by people who know the methodology. And just I want to show this slide, that tangible values and intangible values, how important they are. And here you can see that we are talking about large numbers and large fractions of company assets put in intangible values. You can see that in some companies, even there are no real tangible values, but the major value of the company lays in intangible values, such as patents, trademarks, designs, and things like that. Okay, and then you have to take a decision on commercialization, which will come. One form is the licensing. That comes next time, 15th of April.